everyone. Thank you all for joining us today for our Vendor Contract Management for Beginners webinar. My name is Jessie Redmond, and I will be your host. On your screen, you should see multiple widgets that you can use, including Ask Question, Media Player, Slides, Related Content, Speaker Bio, Request Demo, and Help. If you are unfamiliar with our webinars, all the widget boxes are resizable and movable, so feel free to move them around to maximize your screen space. At the bottom of your screen in the toolbar are icon buttons you can use to show and hide the widgets. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner of the widget. If you experience any issues or have technical questions, you can use the Help widget or submit them along with any other questions through the Ask Question widget. Don't worry, we do capture all questions throughout the session. We will answer some during the webcast, but those that we do not have a chance to answer live, we will address with you via email. Today's live session is eligible for 1 CPE credit. If you wish to receive this credit, please remember to be logged in individually with your own credentials, answer all 3 of the polling questions that appear on your screen during the presentation, be in attendance for the entire live 1-hour session, and complete the follow-up survey. We'll send the link to the survey 24 hours after the live session. If you meet all requirements, we will send your CPE certificate within 7 to 10 business days following survey submission. With us today, we have Kelly Vick, VendMinder's president. She will discuss the vendor contracting process. In this session, Kelly will walk you through the process, show you some contract examples, discuss how this may apply to your current process, share some specific contract considerations, and more. You will see a link to a copy of today's slide deck, a link to our website, a link to our samples library, links to our How to Master Vendor Contract Management ebook, our 5 Steps for a Successful Vendor Exit Strategy ebook, our Mitigating Vendor Risk Through Effective Contract Management Practices infographic, as well as a link to a library of additional resources, all in the Related Content widget. With all that being said, I'd like to hand it over to Kelly. Kelly, the floor is yours.
Thank you, Jessie, and it's good to be here today with you. And as Jessie just mentioned, we're going to cover a few things in this session today about vendor contract management. And you'll see on this agenda, I've got 6 items we're going to cover. We're going to talk about the basics. We're going to talk about some process around vendor contract management. We're going to talk about in detail service level agreements and how to manage contracts ongoing. Talk about some very important rules and things to consider with contract terminations, and then, of course, some key takeaways. So let's start at the basics. What is vendor contract management? In a nutshell, it is the oversight of written agreements that you have with the vendors or suppliers from whom you are purchasing software or services or materials or something, but you have some type of contractual relationship with them. Contract management includes negotiating the terms of those contracts to ensure that all of the provisions and controls that are important to you are included in that contract, and hopefully during your due diligence with that vendor or supplier, you uncovered items that were important to you to include in the contract. It also includes a process for ensuring that the contract is reviewed, approved, and executed properly, and these details should be outlined in your third-party risk management program, and again, hopefully you are following those. Contract management also includes ensuring that all of your vendor contracts, regardless of the value of those contracts, are stored in a central repository with the proper controls. And I can tell you, having worked with many clients over the years when onboarding into VendMinder, that is one thing that continues to be a challenge, is locating all of the contracts. So have that central repository. And it also includes the ongoing maintenance of that contract in ensuring that the terms and things like SLAs are adhered to. So the really key takeaway from this slide is that contract management is not a one and done process. It is time consuming and can be difficult, but it's very important to make sure that you start off with the right foot with a good solid contract. Now that we know what contract management is, let's talk a little bit about why it is important. That contract with your third-party vendor and the negotiation of that contract is a very important tool that will help you have the right relationship, hopefully long-term relationship with that vendor that you are doing business with. It sets the stage. It influences the relationship going forward. Not only is it legally binding, but the work that was put into that contract will set the tone for the relationship going forward, or could set the tone for the relationship going forward. Contract management with the appropriate controls and process brings visibility and transparency into the company's spend, and that helps possibly identify potential cost savings along the way. Planning ahead and inserting appropriate contractual commitments in response to that initial due diligence that you did, that assessment that determined where your risks are. Hopefully you were able to apply some of those controls in the contract, so it's important to help control your risk with that customer, with that vendor rather. And then it's a requirement for all of the major financial regulatory guidance for financial institutions. It's very laid out as far as what needs to be done in your regulations. I'm sure other industries are quite similar. And it's also important to remember that this written agreement is your most powerful leverage in managing that third-party relationship as well. Who is generally involved in the contract process is going to be dependent on the organization. But what we typically see is that there are two sets of people. One are your primary constituents. These are generally the groups, the organizations within your organization who has the responsibility for ensuring that the contracts are written appropriately and managed and stored appropriately. From my experience, what I have seen, certainly could be your legal team, the business owner that has the primary relationship with the vendor and supplier, and then possibly your vendor risk management team. Those three working together would be your primary, the primary team working with the contract and the vendor. But then there will also be people on the sidelines who you are going to collaborate with, and there's very important reasons why you're going to collaborate with them. And you can see there's just a few listed here, and again, depending on your company, it could be others, but certainly information technology, information security, because these are very, very important provisions to ensure that they are set up correctly in the contract. And procurement, depending on the size of your organization. So it just depends on who you are and what departments you have and how you set it up in your third-party risk management governance documents, but it generally involves a team of people. So let's dive into some of the nitty-gritty details that you will find within the contract language. And what you'll see on this slide is these are the major elements that should be included in all vendor contracts. And yes, it's a long list of them. And as we continue to get more regulations in place, more privacy laws in place, you'll continue to see that list grow. But each of these elements should definitely be clearly outlined in your contract. It's important to understand the regulatory requirements that are specific to whatever industry you happen to be in the industry that your vendor happens to be in as well. Again, for financial institutions, I mentioned this a few moments ago, there's some specific places to look that are very prescriptive on what does need to be included in the contract. So I would encourage you to go seek those out. And while all of these elements that are listed on this page are important, I do want to call out that those excuse me, surrounding termination and renewal provisions, as well as the notifications around that, are really the most misunderstood. So be sure that you're very clear with those, and there's no ambiguity in the language when working on those. But regardless of the industry that you are in and the regulations that you are required to follow, or your vendor is required to follow, it does take people who understand these regulations and the guidance and who understand the meaning of these provisions and the impact any changes would make to them. So whether that means you're working with the legal team in-house, or maybe you have an external legal team, whatever it is very important that these be understood. So this here is a pretty good list of all the things that you would want to be sure are included in your contract, the minimum provisions that are in there, and the devil is truly in the details. So when you will get a copy of this presentation, you'll be able to see this list. And then for those critical or high-risk vendors, you will want to even have some tighter controls and some more language around specific elements within the contract, specifically around information security, possibly some expanded confidentiality language, especially if you are working in, say, the health industry around HIPAA, or if you're concerned about privacy, which you should be if it's a high-risk vendor. So the privacy laws you would want to ensure are brought into scope. Especially another element that you will want to be sure you address are the use of subcontractors or fourth parties, especially what data they have access to. And in most cases, when you're working with a critical and a high-risk vendor, there's likely a fourth party involved. So you certainly want to be sure that the language is protecting your data if they have access to it. You probably want to include some third-party compliance documents or audit rights. You want, depending on, again, you would want certain SOC or other third-party audit documents on an annual basis. Maybe you're working with a vendor that has access to credit card data. In that case, you would want to be sure you are getting PCI compliance on an annual basis and the certification around that. And again, because this is a critical vendor, you want to make sure you are working with a vendor who has a very solid and tested business continuity and disaster recovery plan, and that you have access to those. And you could also be working with a foreign-based third party, so there's all kinds of things you need to consider with that, especially where if you ended up going to court with one another, where that might happen. So this list, again, you will receive this when you receive the presentation at the end of this webinar, is not a all-inclusive list, but it's a pretty thorough list to consider. On the next 3 slides, I am going to be providing some example contract provisions. This was one of the requests from the last time that we did this webinar. So again, when you receive this, you'll have access to this. But the first 2 that are being covered is termination for breach and indemnification. Should always have some breach rights within the contract. And, they're fairly basic breach rights, and they generally include a cure clause, which is, fair to both parties. And then indemnification is also fairly standard language that you find pretty typically written the same way from one contract to the next, but there may be some specific carve-outs with indemnification that your organization is looking for. But again, both of these provisions have some pretty standard and common language that you find from one contract to the next. And then we have 2 more, jurisdiction and governing law, and then the authority and organization language. So let's start with jurisdiction and governing law. Well, of course, you go into this contract hoping that neither of you end up suing the other for any reason, but that risk always exists. So you should certainly be sure that you are in agreement with what state and location this would occur, should it occur. I've seen this written too, where there's a mutual, so I sue you and it goes to your location, you sue me and it goes to mine, vice versa. So something to consider there. And as far as our authority and organization, this is, just the kind of the fundamental business of I had the authority to sign this contract and to be in this business that I'm in this business doing. That's what that language is stating. And the final two, intellectual property and reports and audit. So intellectual property, this one, of course, is being sure that each party is protecting their owned property, their owned trademarks, patents, deliverables, their own proprietary information about how they're doing something, especially if you are the one providing the service. You want your knowledge to be your own and not something that is passed on to whoever is buying something from you. So intellectual property is a very important clause to get right between each other. And then reports and audits, this is where you're wanting to ensure that during the term of the contract you have the right to receive certain items from the vendor. Again, this goes back to the ongoing monitoring and the due diligence of that vendor. And so this is where you would detail out what you would expect to receive and whether you have the right to audit the books to ensure that what they are providing you, that they are indeed providing the way they said they were going to provide it. Okay, and no matter how hard we all try, we do see some common mistakes made, and here's just a couple of them that seem to rise to the top. One is executing a contract without doing that appropriate vendor vetting and risk assessment ahead of time, not having the appropriate approval, and of course that's going to be set in your governance document, so not following the guidance that you have established for your organization. Lack of properly tracking that contract and storing it in that central repository, that is a very common mistake we see. And not having the scope of each party's responsibilities clearly outlined in the contract. That one does seem to get missed quite a bit. And here's another one, is no periodic review of the vendor and the contract review during the time you are reviewing the vendor. So with that, this brings us to our first poll question for the day. Jessie, I'm going to turn it over to you.
And this brings us to the first poll question of the day. You should see the poll question now in the slides area. If you have any issues, please feel free to send us a message using the Ask Question widget, and we will be happy to assist. As a reminder, if you wish to receive the CPE credit for today's session, you must answer all poll questions and be in attendance for the entire live session. And this poll question is, in your organization, where does the writing, review, and negotiation of contract provisions generally sit? Procurement, executive management, a general counsel, whether internal or external, the vendor owner, risk management or compliance, other or not sure. Kelly, we have some time now to answer a question from the audience. And this question is, when you perform due diligence on your critical vendors, do you also perform some level of review on your contract with these vendors?
As a best practice, you should review the contract at least annually when you are reviewing your critical vendors. For some industries, especially financial institutions, there's probably language in the interagency guidelines that actually put more emphasis on this than just as a best practice. But during that annual review with your critical vendors, some critical vendors you may review more often than annually, but at least annually look at the contract, remind yourself of those termination dates and the notification periods around them. Definitely look at the performance standards and see if they're in compliance with the SLAs, if there are SLAs. And then another thing you really want to take a look at is, have there been any significant law changes, say in privacy or any other compliance concerns that have changed since you put this contract in place that might need some tweaking and therefore should rise to your attention? So the answer is yes, it is a best practice to have an annual review of the contract with your critical vendors.
Thanks everyone for answering that poll question. Here are the results. By the way, you may have noticed reactions such as a thumbs up or heart coming across the screen. If you find this feature distracting, you can turn it off by clicking the 4 arrows in the top right-hand corner of the slides widget, which will expand those slides to full screen and no longer show the reactions. Also, before we move on, as a quick reminder, in the related content widget, you'll find our How to Master Vendor Contract Management ebook. This is a handy resource to grab as it provides an in-depth walk through all the elements of vendor contract management. Kelly, let's continue with the presentation.
Okay, so let's shift our attention now over to service level agreements and talk further about that. We've always put emphasis on SLAs, but of course, since the pandemic, which is now 4 years behind us, very hard to believe, we have certainly heightened our attention on this topic. So what is an SLA? Well, first, it's an agreement that clearly spells out the performance expectations and how that performance will be measured. It's really plain and simple, although it's not quite so plain and simple to write an effective agreement. But a service level agreement should be a part of every contract with your third-party vendors, at least your critical ones that you are relying on to continue providing good service to your customers. In addition, it defines what's expected. It should also detail how the service is to be measured, as well as any remedies or penalties if the SLAs are not met. So SLAs are a powerful tool to help manage the relationship, but it's also very important that both teams, you and the vendors team, are clear on the role and the expectations of the SLA. These can be very ambiguous, so let's just talk about a few things. One, it's very important that these clarify what is acceptable performance, and you could have a variety of SLAs within the same contract. So it may not just be one SLA, but there may be multiple SLAs that you're going to cover. But the important thing is to clearly state whatever the performance is, what is acceptable. And generally, the reason you have these SLAs in place is because it's all around the customer service, the customer support that you are receiving from this vendor for your customers. So just think about, when writing these SLAs, are you ensuring that this is centered around your customer's experience? And then it's also critically important that whatever the SLA acceptable performance is, that there are solid measurable standards established and written in the contract as well. Otherwise, you may not know that you're getting accurate results from those if you don't know how to measure them. And then even bigger than that is to make sure that if they're not met, then what happens? Are there some penalties? Do you have some ways to get out of the contract if the missed SLAs continue? Of course, missing SLAs can be early warning signs of bigger issues that could be coming. So ensuring that you have all of this wrapped up into a very comprehensive and agreeable SLA is very important for the ongoing relationship. Just like what we talked about a few moments ago as to who should be involved in writing the contract, the same is with the SLAs. Generally the same people, although when it's writing the SLAs, it's very important that the people who know the product and the service the best should be involved in helping to draft those SLAs, because you really want to get down to the nuts and bolts of the product and how it's working, and therefore you should know what the expectations are around it. But again, you should probably have some primary folks, again, the business owner for that vendor, the vendor's account manager who's selling you the product. They are probably going to be a part of that. And then again, your collaborators, your third-party risk manager, that legal team likely might be involved, and the vendor's legal team might likely be involved as well. Again, the critical thing is here that both sides understand what are the business expectations out of this product and service, and how Do we get that down on paper clearly enough so that both sides understand it, and then how is it going to be measured, and then how are you going to get it? How are you going to report on it? So making sure that you have the right people that know that information should be involved in writing the SLAs. So to kind of continue with what I just said about having the right people who know what should be expected with that SLA, help write the SLA. Here's just a couple of examples by vendor type of what you might be including in an SLA. So for core processor, it could include reporting on accuracy and availability and maybe technical response time. Maybe for a call center, you're certainly going to be looking at reporting on speed of answer and call abandon rates. There's probably other things you'd be looking for as well, service, etc. A distribution center, maybe percentage of all the parts being fulfilled completely, maybe number of returns. Cloud provider is definitely the percentage of uptime, maybe a percent of priority tickets resolved on time. These are just some examples. And then software as a service solution, site latency, response rate being response rate to when you click enter or you click something that the system is responding, and maybe an error rate. Again, the information dictated in the SLA will certainly vary based on the product or service provided, but having an SLA with in place for these critical vendors is certainly a best practice and something we all should be doing. Okay, so let's take a look at each one of these. This is going to help you ensure that you are writing an effective SLA. So one, you certainly need to make sure that the expectations and the goals, again, the expectations of acceptable service or acceptable product or acceptable delivery, whatever it is. You certainly want to ensure that metrics as far as how you are measuring the expected performance, what that would be, and the frequency. Is this a monthly thing, a weekly thing, an annual thing? What time period is around that? Responsibilities, again, for both parties. Who's doing what in this product and service around this SLA? Timing and frequency, I just mentioned, not only timing as far as how often are you measuring the performance, but how often are you going to receive reporting on the SLA adherence. And then you want to be sure that, again, this SLA covers the services covered by the SLA, and I mentioned that a moment ago, that you could potentially have a couple of products or services with this vendor and they have different SLAs. So you want to make sure that that is clear. Any key terms in that SLA need to be defined, such as uptime, availability, priority, resolution, things like that. Monitoring the process and service level reporting. Again, you want to make sure that you get that reporting and are sure on what you're getting is what you expect. How to escalate and dispute management if there are concerns or questions about the performance. What are the steps in that process? Response and issue resolution. If, again, issues are raised, what's the timing to get that resolved? And lastly, any penalties, including termination penalties for missed SLAs. And with that, we're going to move over to our second poll question. So I'll turn it back over to you, Jessie.
Our second poll question of the day is, for your contracts that include SLAs, how often are you monitoring and reporting on the vendor's performance against those SLAs? Monthly, annually, sometime other than monthly or annually, only when there is a reason to monitor, such as an outage or not sure? Kelly, I have another question here that we can go ahead and answer. And this question is, after a contract is signed, if we find an issue during an annual review with a vendor, what is recourse with negotiating the contract to include language to address the findings?
Well, that is very likely going to depend on your relationship with that vendor, first of all. And also on the severity of the issue or the risk or the issue that you found during that review. It's really a mutual decision between two parties that a contract that is in term can be renegotiated. Maybe not fully, of course. Maybe you're just looking for an addendum or some kind of opportunity to add some language to address the risk that you identified. Either way, it is something that your vendor does not have to comply with. So, having a good relationship with your vendor, your other party from the very beginning of that relationship during the initial negotiation, the initial due diligence, the annual reviews, the quarterly reviews, whatever it is that you have with that vendor, keeping all of those in a positive light would certainly help in a situation should something like this arise.
Okay, here are those results. Thanks again, everyone, for taking the time to answer the poll. Before we move on, I'd like to remind you that you will find our Mitigating Vendor Risk Through Effective Contract Management Practices infographic available for download in the related content widget. Contract management is not a one-and-done activity and should be an ongoing process as part of your vendor risk management. This resource provides more insight. Back to you, Kelly.
So when do you need to start thinking about an SLA? You're going to first, of course, think about them during the vendor due diligence process, because it's during that time when you're going to uncover things about the vendor, especially what you're buying from them, that you want to monitor in the contract, SLAs as well. You will begin really looking at the SLAs, of course, at the contract stage. And so what I want to point out here is, especially if the vendor is leading with their contract, be sure not to assume that SLAs will be included. And so you want to certainly go look for that and request them if they're not. And as you review them, it's best practice to note that any items that are necessary for follow-up documentation, maybe any standards of conduct that need to be included in these SLAs, some ongoing reporting needs. These are things you need to be sure are reviewed with the SLAs and, of course, documented with the SLAs. And then lastly, you will review them or monitor them on an ongoing basis throughout the vendor relationship. So as you are reviewing the vendor and the contract and the SLAs, and however often you are receiving the SLA reports to show performance against the SLA, obviously you will want to review them at that time as well. So it's important to note that SLAs are not one size fits all. There is not one SLA that will cover every situation. It is dependent, of course, on the vendor, on you, on the product and the service. And as I had mentioned a couple of moments ago, you could also have multiple SLAs with the same vendor, especially if you have multiple products with that vendor. So there's just no quick and easy answer to SLAs. It definitely takes collaboration, and it takes time to identify what the appropriate SLA is and what it should include. So we've talked about why you should have SLAs and how to write the SLAs and who should look at the SLAs and how often you're going to review them. But let's talk for a moment about why it's so important to have them and how they protect your organization. One, it helps keep your team focused on what matters. So if you've got a strong SLA in place with a vendor and you're betting on the fact that they're going to adhere to that, so that keeps you from being distracted and straying away from the organization's strategies, because you have some hope, if you'll allow me to say that the vendor is going to do what they said they're going to do on paper. Enforcing those SLA penalties will help protect your organization, because again, if you're monitoring those SLAs and you're being dedicated to that to ensure that they're not missed. If they are missed, then your organization is going to benefit from any penalties associated with it, and that benefit might be that you end up having to sever the relationship, but that is indeed protecting your organization. And again, the whole purpose of putting these in place is improving your customer satisfaction, because this product and service that you are purchasing from this vendor is supporting your customers. So the whole goal is to ensure that you have improved customer satisfaction. And unfortunately, there will be times when an SLA is broken. So when that happens, what should you do? First thing is to move quickly. When something looks amiss, you certainly want to react early. You want to have a meeting with the vendor and the appropriate parties. Remember that escalation process I talked about a few moments ago. Depending on how severe it is, you may involve board or senior management. And you may also want to consider an on-site audit or visit, especially if there are repeat misses. This is where you would want to possibly consider that, because of course it would come with an expense associated with it. And then you may also even want to reevaluate the SLAs if they're just not, maybe it's an agreement between both parties that the SLAs that were put in place are just not the right SLAs, so let's reevaluate them. That's certainly something you might want to consider. But in the end, ultimately, if you're not able to satisfy yourself that the vendor is the right vendor and is going to be able to deliver what they say they're going to deliver in the way they said they're going to deliver it, you have hopefully built into that SLA the right to exit the relationship. And so you may indeed need to do that. That would be, of course, the last resort, but hopefully your SLA was written in such a way that you're able to have an out clause or an exit termination clause as part of missed SLAs. So moving along through our agenda, we're going to talk a few moments about ongoing contract management. Very simple statement: contract management does not end when the contract is signed. I think I've said that a couple of times now, but I'm sure we've all been guilty of it. We work hard to find that right vendor. We negotiate the contract, and we file it away somewhere, and life happens, and we, never come back and look at that contract again. That is certainly not the best practice and not what we should be doing. So remember, contract management does not end when the contract is signed. So let's just talk through a few things that are critical to consider with ongoing contract management. One is tracking those renewal dates. This is certainly an easy item to miss. This is where that central repository and some kind of contract solution or contract software solution is important. And even if that's Excel spreadsheets, not recommended, but whatever way it is to track the renewal or the expiration dates and the notification dates. That's critical, because if you don't want that contract to automatically renew, assuming it has it, or cancel if it doesn't have one, you need to be clear on the notification date so that you can do something about it timely. Another is to schedule regular meetings to address the service delivery, the service expectations, and any deliverables that they might be doing. So this is where meeting with your vendor on a regular basis, your provider on a regular basis, is really important for the relationship as a whole. So establish those quarterly business reviews, or whatever you might be calling them, so that you can kind of both show off what you've been doing, how it's been going, address any concerns, and just stay in touch throughout the relationship. Another one, of course, is tracking those SLAs and ensuring that you're getting the reports that were set up in the contract, and so that you can review them and determine if the SLAs are indeed being met, or if there's any penalties that are owed back to you. And then if you're doing all of these items, you should be able to identify any gaps that might exist, and that could happen along the way with a contract that's been in place for a couple of years, because regulations change, new privacy laws come into place, whatever. So this is a time for you to identify any gaps that might exist that you may need to address with the vendor. Okay, so let's take a few moments and talk about the ever important termination provisions within the contract. Termination language and defining it clearly is such a critical part of the contract and a difficult part of the contract. Highly encourage you to collaborate with others within the organization, legal team if necessary, just to ensure that you clearly understand what the termination language is saying. What we're seeing around auto renewal these days is that it's becoming more and more of a negotiation item, and we're finding more and more of our customers that do not want auto renewal language included. So be sure you know what to expect with that, with your own policies, with your own program, and making sure that happens with your vendor contracts. Notification requirements, having it clear as to what the notification requirements are, the time period around it, where the notification is going, having that tracked so that you are monitoring on a regular basis. That notification time period and the requirements around it is so critical to ensure that a termination is not missed. And then that termination process. What happens with the termination? How does it happen? Are there specific expectations as to what it takes to actually terminate the contract? What happens after it is terminated? What happens with the data? There's all kinds of things that need to be considered in that termination process. So this is a very complicated part of the contract that needs the appropriate attention placed on the provision. There are typically 4 ways a contract can terminate. One is it just expires. Again, there's no auto renewal clause in the contract. There's a specific time period established in that contract, and that time period comes about, and therefore it expires. If that's how a contract is written between you and a vendor, you certainly want to be tracking that expiration date, because if you're relying on that service and then all of a sudden it's gone, you want to be prepared for that. Another, of course, is a breach of or cause of termination. And there may be breach language in the contract that's mutual. Maybe it's not. Maybe it is purely one-sided and in your favor with being the customer of that vendor. But be sure you understand what those breach clauses are in the event that you need to act on them. Another could be a convenience termination. This is where you, or if it's mutual, either party, at any point in time, for any reason, it doesn't have to be cause, it certainly doesn't have to be that the term, that the contract actually expired, but at any point in time with appropriate notification, you can cancel the contract. If that's what you want to have with your vendor, be sure that that is clearly outlined in the contract. And then there could be reasons other than above for an early termination. Maybe it's related to bankruptcy or some government regulation, maybe some significant privacy concern or something like that. There could be other reasons that a contract could terminate early. Okay, so let's talk about post-termination rights. One is to ensure that you have a transition plan in place. If you're going to be leaving one vendor and going to the next for the same service, are they going to provide any assistance to help you make that happen? How do you get the data back that needs to be moved into the new system? Is there any time period in which that can occur? Things like that. Data ownership, how do you get your data back after termination? Maybe you want to ensure that they destroy the data that they have in their system and provide you a certification of destruction of that data. So making sure that the contract discusses the ownership of the data and what happens to the data after termination. Confidentiality of the relationship should extend beyond the termination right. So you want to make sure that there's some surviving language in the contract that picks up confidentiality rights. And then lastly are licenses. Maybe the relationship with the vendor provided you with some deliverables, reports, outputs, et cetera, and you want to ensure that you are that you're licensed to have those continue post-termination. And with that, that's going to bring us to our final poll question of the day. So Jessie, I'm going to turn it back over to you.
Our third and final poll question is, does your third-party risk management program require data deconstruction to be a part of your vendor contracts? Yes, but only for vendors who have access to customer data. Yes, for all vendor contracts. We do not require data destruction for any vendor contract, or not sure. Kelly, let's go ahead and answer another question from the audience. And this question is, are SLAs required for all third-party vendor contracts?
To my knowledge, there is no regulatory requirement in any of the industries that we are familiar with that requires it. It's just very impractical, if you will, to have SLAs in place for all of your vendors, including low and moderate vendors. Just not easy to find SLAs for all of these vendors, for one thing, and it's just not worth everyone's time to have them in place. So spending your time and to develop very good, worthy SLAs with your critical vendors is what you should be doing. These are the vendors that will cause a negative impact to you and your customers and ultimately your reputation. So spend your time there. They're also the ones that, of course, had access to your customer data. So you want to make sure that, that you have all of this strong contractual language, including SLAs for those critical and high-risk vendors. So again, spend your time with them and don't worry about having SLAs in place with every single vendor contract that you have.
And here are those results. Thank you everyone for answering this question. Before we continue, I would like to mention that we have our 5 steps for a successful vendor exit strategy ebook within the related content widget. As Kelly discussed exit plans and termination, you'll want to check out this resource to learn even more about vendor exit strategies. Let's continue with the presentation. Back to you, Kelly.
Okay, so let's end today's webinar just going over some key takeaways from the things we've talked about today. So first is to clearly define that contract management process within your third-party risk management program. So inside your governance documents, your program and procedures document, and your policy, program, and procedures document to be sure that you are clear on how contract management works within your organization. Be sure that you manage the risks that you identified in that initial vendor due diligence in the contract. So you've identified some risks. You want to make sure you cover those risks when you are writing the contract with the vendor. Understand all those termination rights. Remember, we just talked about that, and there's so many things to consider, and it's such an easy part of the contract to miss as far as having it thoroughly defined what will happen, how you can terminate, what will happen at termination, and what happens post-termination. So be sure that all of that is covered. That SLA that we spent a great deal of time talking about, be sure that it is straightforward and clearly defines how the performance of that vendor will be measured. And then not only do you want to make sure the SLA is in place, but you want to monitor the vendor's performance against that SLA and against the other contract terms. So don't forget that, again, contract management and SLA management is not a one-and-done process. And ongoing monitoring of both of those are very important to a successful vendor relationship. And use a reliable tool or solution for contract storage and for tracking those very important termination dates, notification dates, and any other information that is necessary to be tracked. And then lastly, understand that contract management doesn't end once you sign the contract. It is an ongoing process that requires your attention from the time you sign it until the time you end that relationship with that vendor. So with that, I want to thank you all for joining me today, and Jessie is going to close us out. So Jessie, I'll turn it back over to you.
Great, thanks so much, Kelly. Before we dive into more questions and answers, I would like to thank everyone for attending. I would also like to thank Kelly for her time in sharing some important information. On your screen now, you will see our upcoming webinars. On May 9th, our Performing a Complete Vendor Contract Review webinar, and on May 21st, our Strategies to Mature Your Vendor Risk Management Program webinar. We hope you will be able to join us for those sessions. A link to register for those is in your copy of today's presentation slides. And let's now go ahead and answer some more questions that have come in during the session. Okay, Kelly, our next question is, what are best practices to track SLAs against deliverables laid out in contracts?
There's probably a number of ways in which that can be done, but one way to do that is to make that a part of your ongoing monitoring. Now, really, if it's SLA that you're monitoring for performance of your vendor, you want to review it more often than annually. So setting something aside on a monthly basis, and that's going to depend too on how often you get SLA reporting from your vendor. One of the most important things to do, though, to be sure that it is being tracked effectively, a best practice is to have somebody responsible for it. If there's not an assigned person who is responsible for tracking SLA performance, then it will, can easily go by the wayside because nobody knows it's theirs to do. So I'd say first start with that. Start with assigning somebody and then having a set established time period based on whatever the SLA is. And you may have multiple SLAs with a vendor, and maybe the SLAs have a different reporting period. As I had stated earlier, I mean, SLAs can be so complicated because of the type of SLA, and there's just, again, no cookie cutter way to do an SLA and to follow up on it. But assign it to somebody and set an established time period. Those are probably two best practices to put in place.
Great. And our next question. What is a good way to formalize the exit or termination for a vendor?
Again, this is, a couple of ways in which you can do it, but one way is to look at it is to reverse your onboarding process. Just whatever steps you took to onboard a vendor, and hopefully you took some steps, is just to kind of go backwards in those steps to exit a vendor. Another suggestion is just to develop a very thorough checklist and insert that checklist in your termination process, because in some vendors, depending again on whether they're critical or whether, what data they have access to, who all has the access to the data as far as fourth parties go, there could be a number of items on the checklist that some vendors it's not relevant for them, but understanding what a thorough checklist is for your most critical high-risk vendor who has fourth parties where data resides in places other than that third party. If you have that thorough checklist identified, and then as you're working through a exit strategy with a vendor, then you have a checklist to follow. So you need to make sure you have identified who the stakeholders are, what the termination timing is, did you provide the appropriate notification, are you requiring to have some type of transition period with the vendor so they can help you migrate your data and the process over to another vendor? Are you requesting that data be deleted, and have you gone through that process with the vendor to ensure that the delete process is certified and that you get that certified document in place. And again, knowing the time period is very important, and not just the date on when you're canceling the contract or the contract cancels, but the time period you need to back up the few months to start that process, and then however many months post cancellation date that it will take to get through the process. So having the thorough checklist and a thorough timeline is the best way to get started with formalizing that exit process.
Great, thanks, Kelly. Our next question. Should my contracts for my low-risk vendors be different than my contracts for my critical or high-risk vendors?
Probably. With your critical and high-risk vendors, for certain, you're going to include some provisions that I had mentioned previously that are not going to be relevant for low-risk vendors. And plus, it's just a very lengthy, cumbersome contract to work through with low risk and moderate vendors, low risk especially vendors, and there's just no reason to put yourself and your vendor through that process for the low risk vendor. So find a simple contract template that you're happy with, that you could lead with your low risk vendors, or your low risk vendor probably has a online click-through agreement that would be acceptable as well. But by all means, it should be a different process between the two. From my experience, I'm speaking from my experience and from what we see.
Perfect. Our next question. Would breach notification language be something that should be part of every contract?
Well, it definitely needs to be a part of every contract that is with a vendor who has access to your data, by all means. And quite honestly, you don't see it in all the contracts like you would expect, especially as much as we've seen in the news and in the world these days with cyber breaches and stuff. You would just expect it to be automatic. And so many contracts that exist today that we've all signed that have been in place for years probably don't have it either. And those are the relationships and contracts that you would want to consider a modification in term to include additional provisions to strengthen the contract, such as breach language. So absolutely, yes, it should be included. If you are working with a vendor who has access to your data and your customers' data, breach language should absolutely be included.
Great. I think we have time for one more very quick question. Could you describe an example of ongoing monitoring paragraph or of what contract language may look like?
It can honestly be as simple as a vendor agrees to annually, or whatever period you're looking for, provide to customer standard due diligence documentation, including, and then you would put whatever documents you're looking for: financial, certificate of insurance, third-party audit reports, et cetera, et cetera. So it literally could be a one-sentence statement. And if you're looking for some specific documents, I would include the documents in them as well.
Great. Thanks so much, Kelly. Unfortunately, that is all the time we have left for questions today. Thank you again, Kelly, for taking the time to address some of those that came in. Any questions we did not have time to answer, we will address with you offline. We would like to thank you all for attending and hope you found today's session valuable. Another big thank you to Kelly for her time and content. You can ask even more questions inside of our third-party think tank, an online community that is dedicated to third-party risk professionals and free to join. Just because today's session has ended doesn't mean the conversations and questions must. Post your questions at thirdpartythinktank.com and see what your peers have to say. In the community, you will find thousands of free educational resources, including ones related to vendor contract management. If you would like to become a member of Third Party Think Tank, you can register on the site or shoot us an email and we'll get you registered and send you a link to set your password. We did record today's session, and that recording link will be provided to you in a follow-up email that you will receive tomorrow afternoon. Also in the follow-up email will be the survey link for you to request the CPE credit. On behalf of Inminder, it has been a pleasure. Thank you all and have a great rest of your day.